let your voice be heard right here on WHCR 90.3 FM, the voice of Harlem.
Your Voice We Heard Radio. Good morning. This is Alyssa Fuchs. I'm here with the Quickie. It's time for me to break down King versus Burwell. That's the latest challenge to the Affordable Care Act that has gone to the Supreme Court. And the entire case is basically about what 4 words mean. Those words are established by the state. So what's going on? As we know, last year, the Supreme Court heard a case about Obamacare. They upheld the constitutionality. However, there was now a new issue being raised about the subsidies. Now, here's exactly what's going on. The petitioners, which is a group of conservatives, are making the argument that because the law itself says the words that in order to get subsidies, subsidies are only available to people who buy their insurance on an exchange that's established by the state, and that because in 34 states the federal government has stepped in and stood in the state's shoes and established a federal exchange instead because those states have decided not to expand their own exchanges, that subsidies are not available in those states. Now, essentially, if the petitioners' argument was to win in the Supreme Court, it would effectively destroy Obamacare because all of the people that live in those 34 states that purchase their insurance on the federal exchange would no longer be able to get the subsidies, which make it affordable. So you have 2 real things going on right now. And it's all about kind of interpretation and also about who's doing the interpretation. The respondents, which is the U.S. government, have responded. That's what respondents do. And they have essentially said, no. You know, you can't just look at the exact 4 words that were written in the statute. You have to look at the entire context of the entire law. And there was no way that Congress passed this law that they did not intend subsidies to only flow to the states that established their own exchange. Now, on the other hand, the petitioners, the people bringing this law, they responded to that argument by saying, no, that's exactly what Congress intended, because Congress wanted to force states essentially into setting up exchanges. And so Congress intended that the subsidies would only flow if you set up your own exchange in order to make these states go forward and set up exchanges, because these states would know if they didn't set up exchanges, then they would not be eligible for subsidies. So, to answer Selena's question that I sort of answered first, which is what would be the outcome of a ruling? Well, if the Supreme Court was to rule in favor of the petitioner's argument, then essentially it would nullify all of the subsidies that go to everybody who buys their insurance in 34 states. And so in 34 states now, most people would no longer be able to afford their health insurance because they would now not be eligible for a subsidy. On the other hand, people who live in states that did expand their own exchanges technically would still be eligible for subsidies. However, if you have a situation where now people in 34 states, which is the majority of people living in this country, now cannot get subsidies and cannot buy insurance on the exchange, that could potentially have the effect of collapsing the entire system. And so if the entire system collapsed, then your health insurance, and even in a state that had its own exchange, could potentially go away. So there's obviously a lot at stake here. Now, but there's also a lot of irony involved in this, because there is a doctrine known as constitutional avoidance. And what constitutional avoidance says is that the Supreme Court should interpret a statute in a way that would avoid further constitutional problems. Now, one of the main things that was raised during oral arguments by Justice Kennedy is what he calls a serious constitutional problem with this attempt to kill Obamacare, because he says if we read this phrase established by the states to exclude these 34 states, and then that sets up a further constitutional problem because of an old case called New York versus U.S. Now, to understand a little bit about what I'm talking about, you kind of have to understand New York versus U.S. I'm not going to go into the details of that case because they're irrelevant and they're sort of confusing. But the outcome of that case is essentially to say that the federal government can incentivize states into doing something. For example, the drinking age. Why is the drinking age 21? It's because the federal government says to the states, if you keep your drinking age at 21, we'll give you some money. That's okay. That's perfectly okay. However, the court has also said, in this case, New York versus U.S., and in several other cases, that the federal government cannot commandeer the states into doing something by requiring that these states assume the liability for the fallout if they fail to comply with a federal law. Essentially, the Supreme Court has said that this type of you take responsibility provision is impermissibly coercive, and therefore it violates the 10th Amendment rights of the states and violates the principle of federalism. Now, that's ironic because conservatives are always yelling yelling and screaming about the 10th Amendment and about federalism. And now these people, the conservatives, are making an argument that essentially the state should take responsibility for the fact that they didn't establish an exchange and they should deal with the fallout. It's that notion that violates the Constitution or potentially violates the 10th Amendment of the Constitution. So when we look at the doctrine of constitutional avoidance, we have to say, well, which position that's being put forward would be more likely to violate the Constitution, and that means the least likely to be adopted. It's the petitioner's position is more likely to lead to a further constitutional problem, whereas the government's position, which is that subsidies are available in all the states, avoids this anti-commandeering and federalism issue, which seems that you may kind of get Justice Kennedy to come along with the more liberal members of the court. He's definitely going to be a vote in play. There's also some other things that are going on that you should know about. The first one is standing. Standing is the idea that in order to bring a lawsuit, you actually have to have some kind of injury. In this case, the petitioners, the people who are suing, have actually benefited from the subsidies. In fact, 2 of them are veterans, so subsidies don't even come to play at all. And the other 2 people, I think, have actually gotten subsidies that they benefit from. So there's a preliminary question, which is how have these people even been injured such that they could bring this lawsuit? Now, unfortunately, it seems like the Supreme Court didn't give a lot of focus. They didn't have the lawyers speak a lot about the standing issue. So as much as I think a lot of people see it as an issue, I don't necessarily think it's going to come into play. You have constitutional avoidance. That's something I just mentioned. You also have another issue, which is called Chevron deference. So who is the agency that's in charge of dealing with the subsidies? That agency is actually the IRS. Under this rule called the Chevron rule, the Supreme Court is supposed to defer to the IRS, to the agency in charge's interpretation of the law. The IRS has actually interpreted the words established by the state to mean exchanges that have been established by the states themselves, like here in New York, but also to mean these exchanges that have been established by the federal government standing in the shoes of the states. So then there becomes this other question. Does this Chevron deference apply? And if it does, then does the court just have to defer to the IRS's interpretation, which says that these subsidies should be available for everybody? And then there comes the final issue, which is the issue you're hearing a lot of people talk about, because it's a very easy issue for people to understand, but they don't realize that they have to look at these interpretation issues that I'm going to mention in just a second in the context of the other legal issues that I've just meant. And these are plain language versus context. And this is very simple to understand. On the plain language of the statute, it says established by the state. Just like the petitioners are arguing, they're saying that means you have to have an exchange that's established by the state itself. They're looking just at the plain language. And then you also have the context interpretation, which is that's looking at the law as a whole, which is what was Congress intending. And as we've already mentioned, it's pretty obvious that Congress was intending these subsidies to flow to everybody. So, basically you have all these doctrines in play. It's really, really hard to know which way the court's going to rule. On one hand, you know that Scalia, Alito, and Thomas are probably going to come down on the plain language, and they're going to say, well, it says established by the states, and these exchanges were established by the federal government, and so, therefore, subsidies are not available. On the other side, you're going to have Breyer, Kagan, and Sotomayor, and also Justice Ginsburg. Those 4 justices are going to say, no, let's look at the context, let's look at Chevron, let's look at constitutional avoidance, and they're going to say, the subsidies are available. And then you're going to be left with John Roberts and Anthony Kennedy. Now, we already know John Roberts was the vote in favor of upholding the Affordable Care Act back in the last case, so we don't really know how he's going to go. And we know that Justice Kennedy, based on his questions during oral arguments, is very concerned about this constitutional avoidance problem. He's very concerned that if he adopts the petitioner's positions, that it's going to lead to this commandeering problem and a further constitutional problem with federalism. And so I think my thoughts is that he's actually going to go more with the liberal justices. The final point that I'll make is that all of this is over 4 simple words, and with so much at stake, this easily could have been avoided with the proper drafting. I redrafted the statute. I'm going to read you my redrafted statute now, which is the statute. The law should have read, subsidies are available to anyone who is eligible for them as long as they buy insurance on an exchange, regardless of whether that exchange is established by the state governments or the federal government itself.
I mean, who drafts them? Like, was that was it an oversight, Alyssa?
It was 300 pages. Things happen.
Congressional. That's an interesting question that you bring up. I know we have about one more minute before we have to wrap, so I'll answer that. Which is a lot of times it's congressional staffers that draft them, and a lot of conservatives have raised that point. Which is one of the architects of the law, Jonathan Gruber, has gone on television and he has said he's actually agreed with the petitioners. He said no, it was drafted that way to force the states. But a lot of Congress people have said, he may have thought that, but when we read the statute, we didn't think that before we passed it. So there's obviously also a disconnect between the actual congressional staffers which are normally lawyers that write the laws, and then the Congress people themselves. And there can be a difference in what the thoughts are in the people who draft the law's head versus what is in Congress's head. And there can be a different intent between the drafters and Congress. But ultimately, the court is not looking at the intent of the people who physically drafted the law. They have to look at the intent of Congress, because when it comes down to it, Congress is the branch that reviews the law and then passes the law.
Who knew 4 words could cause so much problems? Almost just like what? President Obama is black, right?
I know another 4 words that cause problems.
That is 4 words.
Pregnant.
Ooh, that's good.
You see?
So look, see, 4
no,
words.
But that's
four
only
words.
3 words.
Or is it?
Yeah, I am pregnant. It's only 3 words. Selena's was better. I'm giving Selena, not just because it's International Women's Day, but Selena gets the win.
Enjoy your 23 hours. Guys, we'll see you next week.
Enjoy it. Thank you so much for tuning in.
I got it for the Lolo. I'm in love with the coco.